Hello there. What you're about to hear is this judge doing exactly what I predicted weeks ago that she's going to do in the end when they get to closing arguments time and jury instructions. In fact, you can go back and look at my videos, and I said very clearly there's no way that this biased judge is going to allow a Bowden defense instruction. It's instruction to the jury. I'm going to go over exactly what that is per Massachusetts law. And I called it that way because she is specifically, deliberately, willfully involved in the actual suppression of exculpatory evidence, including with Lally, to lead the Alberts to testify that at no time was there any incidents of dog attacks. And there was an investigation hired by private investigators that found two people was attacked by that dog, and there were hospital records. She impounded the records, the animal control records, meaning took control of them so that the public could not have access to them. And knowing that those records exist, knowing that there's witnesses that said that they did attack them, when an attorney finds that there's evidence that their client or their party or whoever witness is lying, they have a duty to expose that evidence. So instead of allowing the defense access to such exculpatory evidence, they seized the records, impounded them. So there we are now, weeks later, we're at the jury instruction hearing. So she's going to say, what the instructions are going to be, some things that she had, said there's going to be reserved for later. This is her saying she is not going to allow the Bowden instruction. And this is what I said that she's going to do, because she is, in fact, a part of suppressing evidence that allowed Lowley to commit a criminal act of suborning perjury, leading a party to get on the stand, swear under oath that they will testify to the truth, and then lie. And no, they would not have got on the stand and lied, but for they knew they would be protected by the judge. This is why this judge is, for various reasons, biased. But here we go. She's going to say she's not going to allow the Bowden instructions. So after the last day, after the defense rested, they went for lunch, whatever, and then they came back and had the arguments about jury instructions. So here you go.
I should say right off the bat, I am not going to give a Bowden instruction.
And that's exactly what I said she would do. Very biased. So here you have, I'm going to show you what a Bowden instruction looks like. This is literally what it would look like. This is under massachusetts.gov. Omissions in police investigations. This is like what would be instructed to the jury with the other instructions if a Bowden instruction was allowed, which basically is a third-party culprit defense. You have heard some evidence suggesting that the Commonwealth did not conduct certain scientific tests or otherwise follow standard procedure during the police investigation. This is a factor you may consider in evaluating the evidence presented in this case. With respect to this factor, you should consider three questions. First, whether the omitted tests or other actions were standard procedure or steps that would otherwise normally be taken under the circumstances. Second, whether the omitted tests or actions could reasonably have been expected to lead to significant evidence of the defendant's guilt or innocence. And third, whether the evidence provides a reasonable and adequate explanation for the omission of the test or other actions. If you find that any omissions in the investigations were significant and not adequately explained, you may consider whether the omissions tend to affect the quality, reliability, or credibility of the evidence presented by the Commonwealth. All of these considerations involve factual determinations that are entirely up to you, and you are free to give this matter whatever weight, if any, you deem appropriate based on all the circumstances. So here you have two independent expert witnesses that was hired not by the defense and not by the Commonwealth, and jurors as people who were observing their behavior were very confused as to who is hiring these people and why are they here if the defense did, and it was just confusion. What that did is it showed their secrecy to hide the fact that these experts had to be hired by the United States government, by two different agencies, because of inappropriate behaviors of the police. It was clear evidence that there was omissions in the police investigations. They had to hire expert witnesses, and so wouldn't even allow the jury to understand why these people are even here. So they had to guesstimate in their own minds of why these people are here. And so you have this massive case that has taken place January 2024 in a 71 count indictment against Massachusetts state troopers by the United States government, arresting and charging 6 defendants, former and current state troopers, had many, many unnamed parties that were, so the defendants were charged with bribery, false reporting, false evidence, extortion, and many other crimes. And so they were charged with being the ones issuing licenses and taking bribes and falsifying records. But the people who received those licenses were many, many unnamed people. They redacted, like there was a lieutenant, there was sergeant, there was many police officers, there were firefighters, there were other state troopers of the Massachusetts who were going along in this scandal and this conspiracy, falsifying records. And so this is not only just those that were involved in a massive statewide conspiracy, but the text messages involved in that case show that they were using their authority, like, well, I'm not going to give him the gold treatment if he's a blank, blank, blank. If I don't like him, I'm going to make his life miserable and I'm going to funk him, basically. And then the messages, they were asking, hey, he's a good trooper friend of mine. Make sure you give him the golden treatment. He's a police friend of mine. Make sure you give him the golden treatment. He's a good, there was so many people involved that are not even charged and named. So that kind of conspiracy to show that they do lie in reports, they do cover for each other, they do give favorable treatment. And that case, I don't know if it wasn't even allowed, but when you have people, a guy that's like in somebody's property, if there wasn't cops there, if there was nobody that was a police officer even involved in that scenario, they didn't know any of them, and it's all he say, she say, then they would have and should have gone into that house and investigated, because he was in a party and he was in that house. That is absolutely a reasonable argument that they did not do that investigation. And he could have used the recent prosecution of state troopers, because we at this time do not even know if some of those people who were involved in that scandal are the troopers involved in this case. And it's quite sad that her lawyers did not even attempt to insert that into this case. But nonetheless, here we go. So this is the this is amended. This is amended through May 7, 2024. This is section 1107, adequate police investigation evidence. Admissibility. Evidence that certain tests were not conducted, that certain police procedures were not followed, or that certain information known to the police about another suspect was not investigated. You had the plow driver that was not investigated, and the FBI, in fact, did verify that his GPS did show that he was there. They did not come up with any evidence of GPS to say, oh, well, we checked your GPS and you weren't there, because they already knew that the FBI had already checked his GPS and he was there. They just tried to just make vague assertions, and he was the one that saw the Ford Edge at the that was there. Not only that, but they state that his phone did not move after 12:25, as if that's when he died. Like, if he had gotten out of the car, and they're saying that there was no movement in his phone after 12:25. But the problem with that is He had to have gotten out of the car, so there would have been movement. But then they say at 12:45 is when the collision happened, and then their own state trooper saw in a Wi-Fi auto connect that she was at the house at 12:36. So there was all kinds of evidence to prove that these people have lied, and their own state troopers have stated your crash collision theory that it happened specifically and precisely at 12:45, which is consistent with all those who lied and then said it's not possible to have happened at 12:45. So Trooper Guarini contradicted Trooper Paul, because he was the one that said it was 12:45. Lally said it was 12:45, and all the witnesses said it was 12:45, but there was other evidence that showed, and they had that evidence. So they should have done investigations. They failed to do investigations, and because they failed to do investigations, the FBI had, in the Department of Justice, had to get involved and investigate the investigators. So the fact that they have expert witnesses, it's never happened before that I've heard of, that are testifying and not even allowing the jury to hear who hired them. It is very clear. She has a very clear case for the Bowden instruction. And it's the biasness of this judge who colluded with the DA to suborn perjury, knowing hospital records exist that clearly show there was allegations that dog attacked other people. And knowing that those exist allowed those people to say there was never any other allegations, not whether or not the dog attacked them, but that there was allegations when they specifically said there was allegations. So there's just, I don't think there's any other clear case that should have had the Bowden investigation. But as we go along, jury instruction: if evidence under subsection A is admitted, the judge may give a specific instruction to the jury regarding the permissible inference that may be drawn from the evidence. Even in the absence of an instruction, counsel may argue the issue, provided the argument is based on the evidence in the record and any permissible inferences that may be drawn from that evidence. So even if something wasn't argued during the course, if they have anything they presented and published and made it into, even if they don't, if there's points about some document or video or photo that wasn't even specifically argued, as long as that, whatever that picture or document was admitted as evidence, they can talk about anything in that document, anything in that photo, anything in that video, right? So this is why closing arguments can get pretty tricky. Even in the absence of instruction, counsel may argue the issue, provided the argument is based on the evidence in the record, like the footprints, day 7, made between 5:30 and 6:30 a.m. at her tail light. They provided a video with those footprints at her tail light. Okay, so he's already discussed in this hearing that he is going to show the pictures of the tail light. He's going to really try to hammer it to the jury. It was very clear that it's not broken. Okay. But sadly, nobody's discussing the footprints. Okay. I guess they didn't catch that, but those footprints are very important at her tail light because she didn't make them and somebody did. And then at 8:23, her tail light's missing. Anywho's, moving along. Any permissible inferences that may be drawn from the evidence. And so this is the case. This is the stare decisis. This is the argument that led to this instruction. Subsection A. The subsection is derived from Commonwealth versus Bowden, a 1980 case. Evidence concerning the inadequacy of a police investigation is known as Bowden evidence, and a defense based on the inadequacy of the investigation is known as a Bowden defense. A defendant may argue that deficiencies or omissions in the police investigation create a reasonable doubt to the defendant's guilt. And remember what I said. I said if the jury's not allowed to hear something, then, they're not going to be able to consider that. So I called it. I said she's not going to allow it. I'm telling you now. But hopefully the truth will win over deception. That's my prayer. Commonwealth versus Moore, 480 Massachusetts, 2018. Once determined to be relevant, Bowden evidence is admissible unless its probative value is substantially outweighed by its prejudicial effect. See Commonwealth versus Matte. Judge erred in refusing to permit defendant, a convict on work release, to question police about their failure to investigate criminal records of other employees on duty at time of crime because evidence was critical to defendant's core theory of misidentification. So in this case, you have Jennifer McCabe, who the defense's experts say she made those searches at the time stated. Furthermore, the state's own witnesses contradict each other, stating that she auto-connected to Wi-Fi at 12:36, and even Trooper Barini admitted that he took 36 steps at 12:32 per the health app, and there wasn't anything to counter that. They didn't even focus on trying to counter that. They just tried to counter the other times in the Health Fit app. So for him to be moving at 12:32 and her signing in at auto-connect at John O'Keefe's house to the Wi-Fi at 12:36 is not possible because it's 10 minutes away. So, judge erred in refusing to permit. Okay, so the Bowden defense is a two-edged sword for the defendant because the introduction of Bowden evidence permits the Commonwealth in rebuttal to explain why police did not conduct the investigation suggested by the defense, Commonwealth versus Silva, Santiago. And the more wide-ranging the defendant's attack on the police investigation, the broader Commonwealth's response may be. So I believe she only allowed him to put things in voir dire and even tiptoe in that direction is because if you notice throughout the whole trial, Lally was more busy trying to attack anything that they had to prove that there's corruption going on here than more evidence that they proved that she had done anything. And their own witnesses attacked the other witnesses. So they're clearly... Anyways, moving on. In Commonwealth versus Brum, it's not error to admit otherwise inadmissible and conclusive results of DNA and occult blood tests conducted by police where defendant attacked the adequacy of the investigation. However, a broad Bowden defense does not render the trial devoid of evidentiary constraint. The trial judge must be alert to the potential that the rebuttal evidence may come close to or cross the line between a permissible account of the police investigator's rationale for pursuing a certain suspect or investigatory direction and an impermissible expression of opinion of the defendant's guilt or implicit comment on a witness's credibility. Commonwealth versus Wiggins. Testimony that evidence collected during defendant's booking was removed from police custody by someone who was not a member of law enforcement was properly admitted to show why evidence was not available at trial, where defendants attacked the integrity and adequacy of the investigation throughout the trial. Hearsay testimony to rebut Bowden defense improperly admitted where testimony introduced at least one possibly relevant new fact and could have affected jury's assessment of witness credibility, but was not relevant to establish adequacy of investigation. Comparison between Bowden and third-party culprit evidence. The same evidence must be used to support a Bowden defense and a third-party culprit defense, but the defenses are legally and logically distinct. Third-party culprit evidence is used to suggest that someone else committed the crime. Bowden evidence is used to suggest that the evidence at trial may be inadequate or unreliable because the police failed to conduct the scientific tests or to pursue leads that a reasonable police investigation would have conducted or investigated. I mean, come on now. Leaf blowers, collecting cups, blood in cups, plastic cups, and he even admitted that he didn't even know you're not supposed to collect blood in plastic cups. I mean, we can go on and on and on. And these tests or investigation reasonably may have led to significant evidence of the defendant's guilt or innocence. This information is not hearsay because it's not offered to show the truth of the matter asserted, but simply to show that the information was provided to the police. They didn't even pursue Lucky. They didn't go after, not only did they not go after other people that dog attacked, but they impounded the animal control records to withhold the defense from having that, and the public. Therefore, it does not have to meet the standard for hearsay evidence regarding a third party culprit, particularly the requirement of substantial connecting links. So when you think of third party culprit, you have to look at motive. So, what would be the motive of the Alberts? Well, they kind of suggested the Colin, there was a stiff. Higgins, there was a stiff between, this romantic flirty thing. But then there was the dog causing injury that was very apparent he was going to die. They would have been charged with negligent homicide. That is motive. Okay? So those records of other and evidence of other people having been bit by that dog, because there's animal control records that show that, because there's hospital records, not only did they not pursue that and allow these people to lie and say their dog never attacked another person, but when they have evidence that was uncovered and said, hey, here's these witnesses, and they have hospital records that dog sent them to the hospital, they suppressed that. They suppressed that so that they can deny both the Bowden instruction and the third party culprit evidence. It was very, very deliberate and calculating. And that's why they should be removed from power. Judge properly refused to permit hearsay to be introduced as part of the third party culprit defense, but permitted some statements to be introduced as part of Bowden defense with limiting instruction that statements could not be considered for their truth. Commonwealth versus Reynolds. Judge should have allowed defendant pursuing Bowden defense to question police detectives about tips received by confidential informants, because defendant was not offering the substance of the informant's tips for the truth of the matter asserted, but rather the fact that the tips occurred and were not investigated, such as the other people who were attacked by that dog. When you have Alberts lying and saying their dog never harmed anybody, that goes to motive of why they would have put him out on the lawn and to protect themselves of losing everything and having children who would be affected by having, their parents having caused, it's just egregious. They would have gone to prison. They would have, if they would have been charged. And yes, people who negligently cause a death because of their dog are charged. Happens many times. And especially when they know that dog caused 2 other people to go to the hospital. Yes, they could absolutely have been charged. So that's a motive for them to do a cover-up. That in itself. Third-party culprit evidence may be admitted regardless of whether the police knew of the third party, whereas Bowden evidence is relevant only if the police had learned of the information during the investigation and failed to reasonably act upon it. So this is why I said the judge is not going to allow it, because she was personally involved in the cover-up. She literally was. She personally, the judge who issued the order to impound the animal control records after it was revealed in a pretrial hearing that there are not 1 but 2 people who have been attacked and sent to the hospital. You have hospital records, witness statements, police animal control records. So she actively, the judge who impounded those records, actively participated in the cover-up and criminally colluded with the DA to lead other suborn perjury for other people to say there was no dog attack. That's why I said there's no way that she is going to allow it in, because she is actively a part of the cover-up. Accordingly, the judge must conduct a voir dire hearing to determine whether the Bowden evidence had been furnished to the police, and if so, whether the probative value of the Bowden evidence is substantially outweighed by the risk of unfair prejudice to the Commonwealth from diverting the jury's attention to collateral matters. And so you have FBI hired expert witnesses testifying that they're not even allowed to know why they were brought in, because the judge doesn't want the jury to know that these people are under investigation, that there's a investigation. And of course, they don't want them to know about the massive scandal involving police and firefighters and Canton tow truck driver and unnamed police officers across the state of Massachusetts giving a widespread deceptive scandal against the Massachusetts state troopers, not just the 6 defendants that was charged in the 71 count indictment in January 2024. But many unnamed people who were aware that they were getting special treatment when they were issued the licenses, give me the golden treatment. Make sure you give them the golden treatment. My good trooper friend, make sure you give them the golden treatment. Okay, so they maybe, for whatever reason, a lot of times the feds, they want to give immunity to people, and it helps them build their case. Okay, that's how things work, and that's why I say, yeah, all those people who know that they lied, they should run to the FBI to get secure their immunity, because eventually, I think with that investigation that was already underway when they took into this case and hired these expert witnesses, they're like, we might have more problems with this Massachusetts state troopers. We might have some more problems. And then you have a very recent case of the Trial 4 documentary released on Netflix, where for decades there was Boston police corruption that was so bad. And this was back in the 80s, and it's just gone on and on, though, because this cop who was violently murdered, they manipulated a conviction, a guy who spent 22 years in prison, and he was eventually completely exonerated. But through that documentary series, they uncovered that state knew that there was horrible, egregious corruption. Not one person was charged. So the state, who has the duty to investigate these law enforcement officers, had plenty of evidence. And you had witnesses, anyways. So the feds, I don't know how long they were working on this case where they just came out with the 71 count indictment in January 2024. But they to keep the jury from knowing, and based on somebody who had witnessed the jurors' reaction when they came in there, and they found out that this witness is not hired by the defense or the Commonwealth, their reaction, pretty much all of them, was just like, they're just looking like, just what on earth, like shocked, like this, like it didn't even make sense. So they allowed the juries to be confused, completely be confused. Meanwhile, of course, she's going to deny the Bowden defense and third-party culprit defense. Unlike third-party culprit defense, there's no constitutional right to present a Bowden defense. There is a constitutional right for the third-party culprit evidence. So, and the exclusion of such evidence is reviewable only as an abuse of discretion. Okay? So that's for appeal purposes, if an appeal is even needed. But third-party culprit evidence, now that's civil rights right there. Okay. Anyways, I won't go into that. Cross-reference section 1105, third-party culprit evidence, subsection B. In closing argument, defense counsel is entitled to argue that the inadequacy of the police investigation creates reasonable doubt of the defendant's guilt, provided that the evidence supports the argument. See Commonwealth versus Alvarez. Commonwealth versus Bowden. Even though it might be preferable for the judge to inform the jurors that the evidence of police omissions could create a reasonable doubt, a judge is never required to give such an instruction. Commonwealth versus Williams. Instead, the judge is simply required not to take the issue of the adequacy of the police investigation away from the jury. Commonwealth versus Wilkinson. That's a 2020 case. The standard instructions that a jury should decide the case based solely on the evidence when given as part of the final instructions, and not during the Bowden argument by defense counsel or in response to a question from the jury, does not impermissibly limit the jury's consideration of a Bowden defense. Alvarez, Massachusetts, at 317-318. If no specific Bowden instruction is given, it is prudent for the judge to omit from the final instructions the sentence, "You are not to engage in any guesswork about any unanswered questions that remain in your mind." Okay, well, what are they supposed to think about those expert witnesses that they're not even allowed to know who hired them? Because an investigation into the investigators is underway. So if anybody, so then sadly, you have the fact that these lawyers are paid most likely on a large flat fee. Somebody guesstimated probably at $250,000 each lawyer. And so they just cut short in the end. They're like, They didn't want to spend the time to bring in